Today we're going to talk about litigation and what that means. Many times when we use that word, people go, what is that exactly? Litigation is filing a formal lawsuit, complaining about what's happened to you. So it begins a formal pathway to the courthouse for a judge or jury to judge your case. Why is this important to know? Well, many times when people go to a lawyer and they talk about their case and they think there's a case, they think it's automatically litigation. But many times cases settle without even having to sue anyone. That's called making a claim. But if we can't resolve the case, we then file this formal lawsuit, which is called a complaint, which gets filed in the clerk's office at a court. And from there, a formal pathway is set up as to how the case must proceed. Now, when we file a lawsuit, there's a few important things to keep in mind. Number one, the burden of proof, the burden of proving your case, and each element of it is on us. The defense doesn't have to prove a thing. So we have all the work ahead of us, along with you, working as a team to present and prosecute your case successfully. Two, litigation takes time. A lot of people think it could be, from TV we think it happens in a few hours or a few days or weeks, but when we file a case, even simple cases can take 1 to 2 years to get to court. More complicated cases, such as if we have to sue a doctor or a bad product, they can take 2 to 3 years. So these cases take time, therefore we must be patient. Now, we need your help. We need your full cooperation when we file your lawsuit. There are a number of things involved that include your time and energy. And we're going to be dedicated to your case, but we have to do it as a team. And we're going to break it down and go over each element of what the case is about. So we're going to walk you through stage 1, stage 2, stage 3 of the case. So it makes sense when we say we're going to litigate, you understand what this is going to be about. As we proceed down the litigation path together, keep in mind you're going to have a dedicated paralegal to your case from KLH. Through this process, we will be vigorous and strong in our presentation of your case. But it's very important that we know everything. We need to know the good and the bad. We have to deal with everything. Remember, what we talk about is confidential. We cannot win your case unless we know everything, good and bad. There will be deadlines that will be explained in this process that we must follow. So we're going to talk about that with you, and we need your full cooperation to make sure we can timely respond and present the case in the best possible way.
Let's talk about the paper phase of litigation. There are 3 steps: the complaint answer step, the written discovery step, and the motions step. In the complaint answer step, we, the plaintiffs, file a formal legal complaint against the other side. The complaint is the document we file with the court that alleges the facts and law that support your case. It is also the document that requests legal relief from the other side, typically in the form of compensation for your injuries. Once we file the complaint, the clerk of court serves the other side with a copy of the complaint and a summons to answer the complaint in court. The other side then answers the complaint, typically by denying the claims against them. Sometimes they make claims back against us or other parties to be involved in the case. Once the complaint and answer have been filed in the case, the parties typically engage in what's called written discovery. Discovery, as it sounds, is intended for the parties to share information about their cases. The idea behind written discovery is to avoid any surprise in litigation. The first step of written discovery is typically what are called interrogatories, which are questions to be answered under oath. Along with interrogatories, the parties usually also serve on each other requests for document production. Both the interrogatories and the document requests are an important part of your case. We will help you answer those, but we will need your cooperation. Interrogatories typically ask about your injuries, your claims, and the facts that underlie your case. A very important part of interrogatories is often your medical history. We'll need your full cooperation and frankness in answering all questions about your medical history. After the written discovery phase of your case, or sometimes during that phase, the parties also engage in motions practice. A motion is a document filed with the court asking the judge to do something. Typically, those motions include requests for the parties to cooperate in discovery, for instance, to provide documents they haven't yet provided. But motions can also include requests for the court to dismiss parties or dismiss claims in a case. We will talk with you about the various motions that might be appropriate in your case. Your answers in discovery are given under oath, which means you are sworn to tell the truth. You might wonder what the other side can ask in discovery. The discovery rules are fairly open on that subject. Discovery, again, is designed for the parties to share all information that could potentially be relevant to the outcome of the case. This means the other side can ask about your past, including your past medical history and other private information. As we mentioned, the litigation process can take 1 to 2 years or more. The discovery phase of litigation typically takes at least several months, if not longer, depending on your case.
After the paper stage of discovery in your case is completed, we move on to the people stage of discovery. The people stage involves taking depositions, both of you, the defendants, and any expert witnesses or other witnesses in your case. A deposition is sworn testimony taken in front of a court reporter. It's usually scheduled in either our office or one of the other lawyers' offices. The court reporter will be there, the other lawyer and the other parties will be there, but of course we'll be there sitting right beside you the whole time. The other side in your case will want to take your deposition to learn about how it happened, how your injuries are doing now and how you treated. We will also want to learn about the other side's version of the case, and that means we get to take depositions of defendant and any witnesses or eyewitnesses that they may call at trial. It's important to remember that we cannot testify or answer for you. You have to answer their questions for yourself, but we'll be able to object to various questions throughout the deposition. Before you give your deposition, we'll go over things like questions that the other side will ask, as well as things to keep in mind while you're testifying. Depositions will normally have to be taken for any witness or party who is relevant to the case. Typically that means the parties, the plaintiffs and the defendants, eyewitnesses to the events that caused your injuries, as well as expert witnesses such as doctors or reconstruction experts.
After the paper stage and the people stage are accomplished, we're going to reevaluate the case. What did we learn? What are the good? What are the bad facts that we need to contend with? The defense does the same thing. This is often when cases go into a mediation process where both sides say, hey, would you like to mediate? See if the case can settle. It's a very common practice in today's environment. The key is we're in control. You make that decision if you want to do it. We're certainly going to give you guidance. And again, throughout the process, we're going to keep you apprised of the jury verdicts, what our research shows us, what are the issues we have in front of us, what are the legal issues that are coming up through the time that we're in court, what are the rulings of the court. These are all important factors to take into account. When we file a lawsuit and the judge gets the case, the judge controls the timing. Each judge is different, and the court will give us certain deadlines by which things need to be accomplished. As we've talked about, there's the paper stage, there's the people stage, and there's testimony from experts and other witnesses. The court usually outlines certain time frames by which we must accomplish this part of the discovery. What's very important to remember too is the court will also tell us about meetings that the court wants with us. These are called status conferences or sometimes pretrials. That's where all the parties, the lawyers and you, and the defendants and their lawyers must meet with the court to educate the judge about the case. What's the case about? How's it going? Are there problems? Could it settle? The court likes to know how things are going, and if there's a problem, perhaps try to intervene and resolve any conflicts. Now that means you're going to have to take off time from work perhaps, or go to court. It's very inconvenient in many respects as people get nervous. We'll certainly alert you to when those events take place and walk you through the process. Statistically, the vast majority of cases settle, but that's because we prepare the case to try it. In this firm, we are ready to try your case. And the other side knows that, and the judge knows it. And so as a result of that feeling they get, they're knowing that we're fully prepared, that we've diligently dug in on the facts, that we're fighting hard for you, they do want to settle often. If it doesn't settle, which again is your control. You're the boss. We'll give you our opinions, but you're the one that makes that final decision. Then we prepare for the actual final pretrial and the trial. We must convince 6 out of 8 jurors that we should win your case. If we're in federal court, there are 12 jurors, and we must convince all 12 that we should win the case. But keep in mind that our goal is to get your case ready for trial, and if it doesn't settle, we're ready to fight it out for you. At all times, we're here for you. We will keep you informed. Don't hesitate to call us or our dedicated paralegal on your case. Email us, phone calls. We encourage that. We want to keep you informed and make you feel comfortable through this process.